March marks 1 year since Donald Trump was first criminally indicted in 2023. Now the former president faces 4 different criminal cases, one alleging federal election interference, another accusing him of election interference in Georgia, a case related to charges over improper handling of classified documents, and a case tied to an alleged hush money payment. I'm Stephanie Haney, and in this edition of In the News Now, we give you the latest update on where each of these cases stand now as we prepare for the 2024 presidential election, where Trump is the presumptive Republican nominee. Trump faces 91 felony counts across 2 state courts and 2 different federal districts, any of which could potentially produce a prison sentence. He already lost a civil lawsuit in New York and was found liable for 2 large defamation judgments. Let's take a look at each of the major legal cases against Trump. First up, the case on falsifying business records connected to a hush money payment. In March 2023, a New York grand jury indicted Trump on criminal charges stemming from payments he made in 2016 to his former attorney, which were said to cover up an alleged affair with an adult film star known as Stormy Daniels. This case made him the first former president in American history to be indicted. At the beginning of April last year, Trump pleaded not guilty to 34 felony charges of falsifying business records in this case. For more on what those charges mean, here's Devin Bartolotta.
Former President Trump faces 34 charges of falsifying business records in the first degree. We're looking into what that charge means in your breakdown. Here's the part of New York State Code which defines falsifying business records in the first degree a Class E felony. The New York court system says this could include removing, creating, or omitting a business record with the intent of covering up another crime. To be found guilty, New York law states that prosecutors must prove 2 things. 1, that there was falsification of business records, and 2, that there was intent to defraud or commit or conceal another crime. The intent to conceal another crime is what makes this a felony charge. That's why the statement of facts in Trump's case doesn't just include the list of charges and alleged false business entries, but also a narrative of the 11 hush money payments the district attorney says he intended to cover up. Prosecutors say Trump orchestrated an unlawful scheme to influence the 2016 election by paying off people and suppressing negative stories about him. The complaint says he, quote, violated election laws and made and caused false entries in the business records of various entities in New York. The DA did not have to name what specific crimes Trump may have been trying to cover up, but it's likely a combination of state and federal election, campaign, and tax violations. And remember, that's important. Going back to our original New York code, for a jury to find Trump guilty of felony falsifying business records, prosecutors will have to prove 1, that Trump did change the ledgers on his business records, and 2, that he did so in order to cover up an illegal scheme meant to influence the 2016 election.
When news of this case first broke last year, this led to questions about whether hush money payments can ever be legal. Ariane Daytil with our National Verify team brings us the answers people are looking for.
On April 4th, the district attorney in Manhattan charged former President Donald Trump with 34 felony counts of falsifying business records.
34 false statements made to cover up other crimes. These are felony crimes in New York State, no matter who you are.
The charges are related in part to hush money payments made during the 2016 presidential campaign. Trump pleaded not guilty to all counts. Several Verify viewers have asked us if it's actually legal to make hush money payments. So let's verify. Our sources are Paul Schiff Berman, a law professor at the George Washington University, and court records in the criminal case against Michael Cohen, Trump's former personal attorney. This claim needs context. Let me explain. Hush money is exactly what it sounds like. Someone is paid money to keep a secret. That could be for things that are legal but embarrassing, like an affair. Hush money can also be included as part of a legal non-disclosure or confidentiality agreement, commonly known as an NDA. While there are no laws that explicitly prohibit paying somebody money to keep a secret, according to law professor Paul Schiff Berman, there are some cases when hush money payments can be connected to illegal activity, like in the case of blackmail or extortion. Doctoring financial records or disguising hush money payments as something else could also be considered illegal. So, how does this apply to former President Trump's indictment? The former president isn't actually being charged for making a hush money payment. He's facing charges for allegedly attempting to cover it up. With your Verify, I'm Ariane Daytil.
This so-called hush money trial has been delayed, with the New York judge on the case ruling to postpone it until mid-April. Now, this delay comes after 100,000 pages of discovery were entered into evidence just 10 days before the trial's original March 25th start date. Now to the classified documents case, where Jack Smith, special counsel for the U.S. Justice Department, has brought 37 felony charges against Trump in connection to the removal of documents from the White House when he left office. Smith addressed the indictment after it came down in June of 2023.
This indictment was voted by a grand jury of citizens in the Southern District of Florida, and I invite everyone to read it in full to understand the scope and the gravity of the crimes charged. The men and women of the United States intelligence community and our armed forces dedicate their lives to protecting our nation and its people. Our laws that protect national defense information are critical to the safety and security of the United States, and they must be enforced. Violations of those laws put our country at risk. Adherence to the rule of law is a bedrock principle of the Department of Justice, and our nation's commitment to the rule of law sets an example for the world. We have one set of laws in this country, and they apply to everyone. Applying those laws, collecting facts, that's what determines the outcome of an investigation. Nothing more and nothing less.
Trump's handling of classified documents has many people questioning who has the power to declassify documents. Ariane Daytil is back again with the answer from experts.
Former President Donald Trump has been indicted on 37 counts related to mishandling classified documents after he left office. Court records reveal FBI agents took 11 sets of classified records from former President Donald Trump's Mar-a-Lago estate during a search on August 8th. In an August 12th post on Truth Social, a social media platform he founded, Trump claimed that the documents were all declassified. The former president's comments prompted several of our viewers, including Beverly and Carol, to ask, can the president declassify documents? So let's verify. Our sources are the U.S. Constitution, Executive Order 13526, Kel McClanahan, Executive Director of the National Security Counselors, a nonprofit public interest law firm, and Richard Immerman, professor and historian at Temple University. According to our sources, a president does have the authority to declassify documents while they're in office, but it isn't a formal process. Let me walk you through the levels of classification in the U.S. government and when presidents can and cannot exercise their power to declassify government records. The three levels of classification in the U.S. government are confidential, secret, and top secret. National security expert Kel McClanahan says the classification assigned to a document dictates
the level of damage that its release would cause to the national security of the United States.
According to the National Archives, a select group of government officials have classification authority, including the president, vice president, and agency heads. But let's focus on the president. The Supreme Court ruled the president's power over classified information comes from executive authority granted by the Constitution. A sitting U.S. president has wide-ranging authority to classify and declassify certain documents, but a former president does not. To classify a document, a sitting president has to make a plausible argument that it's related to national security, according to McClanahan. But he says there isn't the same requirement for declassifying documents.
He doesn't have to give any reason for declassifying it. He can just say, I decide that this should be declassified, and it's declassified.
According to our sources, there isn't a formal protocol the president has to follow in order to declassify government information. But historian Richard Immerman says there is an informal one that presidents generally follow. First, the president consults all departments and agencies that have an interest in a classified document. They provide an assessment as to whether the document should stay classified for national security reasons, and if there's a dispute among the agencies, they debate it. But ultimately, it's the president that makes the decision on declassification. So we can verify, yes, a president can declassify documents, but there isn't a set protocol that they have to follow. So what about the documents found at Trump's Mar-a-Lago estate? Well, there are other federal laws that bar a former president from taking government documents, regardless of whether or not they were declassified. With your Verify, I'm Ariane Daytil.
Following Trump's federal indictment in this case, online claims say when he was president, he made the mishandling of classified documents a felony. So is this true? Brandon Lewis verifies.
Viral tweets from before former President Donald Trump's indictment claim that while he was in office, he increased the penalty for improperly handling classified documents from a misdemeanor to a felony. But is that true? Let's verify using these sources. In 2018, Trump signed the FISA Amendments Reauthorization Act. This increased the maximum detention time for the unauthorized removal and retention of classified documents or material from 1 year to 5. The DOJ classifies any crime that has a penalty of more than 1 year in prison as a felony. Anything less is a misdemeanor. So, yes, Trump did sign a law that upgraded mishandling classified documents to a felony. However, that's not the crime he was just charged with. Trump pleaded not guilty to these charges under the Espionage Act. This is a different law that is specifically for documents related to national defense, and they don't have to be classified. With your Fast Fact, I'm Brandon Lewis.
Now, a trial date for the Mar-a-Lago documents case is still unknown, as it was initially set for this May, but the judge has not indicated when it will actually move forward. Special Counsel Smith recently proposed a July start, but the Trump-appointed judge Aileen Cannon seems skeptical that can happen. She recently rejected one of Trump's attempts to dismiss these charges. Trump says his actions are protected under the Presidential Records Act. Prosecutors say the act applies to personal records, not national secrets. In Fulton County, Georgia, District Attorney Fani Willis brought a huge racketeering case against Trump and 18 others. She alleges a conspiracy that spread across states and spanned weeks with the aim of stealing the 2020 election. The indictment came down in August of 2023. Zach Merchant takes us back to that moment and explains the key points to know.
These are ridiculous indictments.
Former President Donald Trump is the highest profile defendant named in the indictment announced late last night by Fulton County District Attorney Fani Willis.
A Fulton County grand jury returned a true bill of indictment.
He faces 13 charges, including 3 counts of solicitation of violation of oath by a public officer. The indictment alleges at least one of those acts of solicitation happened during the January 2021 phone call between then-President Donald Trump and Georgia Secretary of State Brad Raffensperger, where Mr. Trump can be heard discussing finding votes.
Look, all I want to do is this. I just want to find 11,780 votes, which is one more than we have.
The indictment also accuses the former president of making unlawful false statements during that conversation when he claimed that thousands of dead people voted in the 2020 presidential election.
The other thing, dead people, so dead people voted, and I think the number is in the close to 5,000 people.
Secretary of State Brad Raffensperger responded to that claim on the call moments later.
The actual number were two people that were dead that voted.
Now, District Attorney Fani Willis has come under fire due to misconduct allegations that say she hired a boyfriend to lead the investigation. Judge Scott McAfee ruled that the special prosecutor, Nathan Wade, either had to leave the case or Willis would have to step aside. Wade submitted his resignation just hours after the judge issued the ultimatum. For what this means for the case and what could happen next, here's Ariana Maniz.
Fulton County District Attorney Fani Willis has some choices to make about how to proceed in the Georgia 2020 election interference case. Willis must now decide who will replace Nathan Wade as lead prosecutor after a judge ruled that either he or Willis had to step down for the case to proceed.
Knowing Ms. Willis, she's going to take this on herself.
Former DeKalb County District Attorney J. Tom Morgan predicts Willis herself will replace Wade. Morgan says at this point in the case, it will be challenging for Willis to find outside counsel.
I think it would be very, very difficult to get a special counsel in this case. Under these circumstances, the security issues, the time issues.
He adds she could also hire someone from her office to take on the case.
She also has excellent prosecutors on her own staff. I think if I was Ms. Willis, I would circle the wagons and use the talent that she already has.
Wade had attorneys assisting him. If one of those attorneys could step up and take over the prosecution, I think that'd be the easiest and the fastest answer here.
John Acevedo, visiting associate professor of practice With Emory University School of Law says an attorney who worked alongside Wade could also step in. He says one possibility, attorney John Floyd.
He has experience. He's in private practice and has done both defense and prosecution. He helped very early in the case, someone who knows the ins and outs of the case, the evidence, and could therefore take over with very little time.
Whoever Willis decides to take the lead on the case, Acevedo says timing is key, as delaying the decision plays into the defense's strategy of pushing back the start date to the highly anticipated trial.
I'd be surprised if she took longer than next week. And at this point, I think she's looking to make a quick statement that she's willing and able to continue with this case as fast as possible.
Trump and his co-defendants have re-upped their efforts to disqualify Willis as they filed a motion to appeal the judge's ruling. Teresa Bowles spoke with a legal expert who says it's possible this could delay the progress of the case, but it doesn't have to.
Yet another hang-up in the Georgia 2020 election interference case. An appeal.
The former president and his co-defendants have a right to ask to appeal the decision. They don't have a right to appeal it because it's before trial.
Georgia State University law professor Clark Cunningham says there's a process to this. To move forward, the defendants have to ask the judge to issue a certificate for immediate appeal and get it granted.
Then they have to persuade the Georgia Court of Appeals to take it.
Even if they all agree, Cunningham says it's still going to take time, so he suggests Fulton County District Attorney Fani Willis start the trial as soon as possible because time is ticking.
If she loses the appeal, then she and her team are off the case. But there also is a new commission that the governor signed into law on the 13th that will probably start investigating her and has the power to remove her.
The other option is for Willis to take a leave of absence.
I think it's much less likely that the appeal would go forward, and it would greatly simplify things.
If not, Cunningham says if former President Donald Trump were to be elected again before the trial, he can go to federal court and ask for an order to put a stop to state prosecution as long as he's president. If he wins, then there will be a 4-year hold. Trump can't pardon himself for state crime, but the federal cases can go away. So everything is weighing on the Georgia case and the voters' eyes on the screens.
And all of us can basically sit in the jury box and watch the evidence as it comes in. That could make a huge difference. It could determine who our next president is.
Fulton County Judge McAfee has already dismissed some of the charges against Trump and his co-defendants in the Georgia election interference case. The judge dismissed 6 counts from the original indictment, including 3 against Trump. The judge said they were too vague. Zach Merchant is back now to explain the charges dismissed and their impact on the overall case.
The state, when they charge someone, has to put enough information in their charge to put that individual on notice of what they're alleging or what they said that they did.
In other words, according to former DeKalb County District Attorney Robert James, the law says prosecutors can't just accuse a defendant of committing a crime. They also have to include details about how they allege the crime actually happened.
If that charge isn't specific enough to put a defendant on notice, well, then that's not fair, right? Because they can't prepare a defense.
A group of defendants in the Fulton County election interference case, including former President Trump, argued that 6 counts in their original indictment did not meet that threshold. And in a ruling this morning, Judge Scott McAfee agreed, writing in his order that these 6 counts contain all the essential elements of the crimes, but fail to allege sufficient detail regarding the nature of their commission. He concluded that the counts, as written, do not give the defendants enough information to prepare their defenses intelligently. With his ruling, the 6 counts, all related to accusations that the defendants solicited public officers to violate their oaths of office, are now dismissed from the case. But James says the actual consequences might be limited.
Well, it has virtually no impact.
The former DA, who now works in private practice, says Fulton County prosecutors could quickly obtain a supplemental indictment with more specific language to reinstate the counts, or they could opt to move forward without them.
There are at least 34, 35 other counts, right? And so, there's still a case against all of these other individuals.
Now to the final criminal case against Trump, the federal election subversion case out of Washington, D.C. A grand jury indicted Trump in August of 2023 with charges tied to his attempt to remain in power after losing the 2020 election. Right now, this trial is on hold while the United States Supreme Court hears a case about whether the former president should be immune to prosecution. While a 3-judge panel rejected this argument in February, Trump appealed. Now the Supreme Court will hear the case the week of April 22nd. For more on the charges and what is involved in this indictment, here's Eric Tucker with the Associated Press.
My name is Eric Tucker, and I cover the FBI, Justice Department, and National Security for the Associated Press in Washington. This is an indictment that charges former President Donald Trump in connection with his efforts to overturn the results of the 2020 presidential election. This is the second criminal case that's been brought by Justice Department Special Counsel Jack Smith against Donald Trump as he seeks to reclaim the White House in 2024. This indictment covers a tumultuous 2-month period between his loss to Joe Biden in November 2020 and January 6, 2021, when his supporters stormed the U.S. Capitol in an effort to halt the counting of electoral votes that would have handed formally the election to Joe Biden. During the course of this investigation, prosecutors examined a broad variety of schemes by Trump and his allies to allow him to try to cling to power. Among the many various aspects that the government analyzed and assessed was one that involved enlisting so-called fake electors in 7 battleground states that were won by Biden to assert falsely that they were actually the real electors and that they were casting their votes for Trump. And this is a scheme that was developed by legal advisors for Trump and something that the Justice Department has spent more than a year trying to get to the bottom of. This investigation was really notable because of the very senior Trump administration officials who wound up cooperating with the government, either because they were forced to or because they voluntarily did so. In April, former Vice President Mike Pence appeared for hours before a grand jury in Washington, and Pence is a critical witness because he was repeatedly goaded and pressed by Trump to ignore his constitutional duty, and the former president really demanded that he block the counting of electoral votes, that he deny that process on January 6, 2021. Mike Pence famously refused that overture from Trump, and that caused a significant fissure in their relationship. We also know that Trump lawyer Rudy Giuliani met voluntarily with investigators, and we know that many state election officials, people who are subjected to pressure campaigns from Donald Trump to overturn the election results in their states, they also met with investigators. This indictment is really notable because it concerns a very dark period in American history when a sitting president refused to accept his loss in a presidential election and worked to try to overturn the results. It is a bedrock principle of American democracy that a president or a candidate, when they lose a race, that they step aside and hand over power. And this investigation sought to uncover all the different ways in which Donald Trump failed to do that.
Now the whole country is watching to see how the Supreme Court rules on the question of presidential immunity and what this will mean for the other court cases in play. We do want to note that even if Trump were convicted in any of these cases, he can still run for president. These cases continue to change, so we'll make sure to keep you up to date on what you need to know. Thank you for watching this edition of In the News Now. I'm Stephanie Haney.